The America First Legal Foundation, combating the left's radical agenda.
Fight for the American people, defend the Constitution, and save this nation for the next generation. Hello, and welcome to the next episode of The Arena with America First Legal. We've spent a lot of time introducing you to different guests, different people who are in the arena who've been fighting fights that you may not know as well, and we'll continue to do that. But one of the things that we're going to be doing on the show going forward is we're going to be talking a lot more about our own battles for our clients, the actual arena, the battlefront that is this country and is the legal battlegrounds of this country. And so today's episode is going to be fun because I have the privilege of having a room full of AFL people here with me today. That we'll just introduce in just a moment. And the focus of this episode is for all the parents out there, all the students, all the families out there who are getting ready to go back to school. Or if you're in the South, you probably are already in school. And we know that across America, it doesn't matter which state you live in. It doesn't matter. You can be in a red state, in a blue state. People are seeing things that no one ever thought they would see in our public schools. We're talking about boys going into girls' bathrooms. We're talking about furries, just everything. I mean, I'm telling you, it's crazy out there. We hear from people all across the country. We talk to people all across the country. And if you think that your school, your county is immune from the kinds of things that are plaguing other parts of the country, you are sadly mistaken. Unfortunately. Now, there's been a lot of great things that have happened recently at the Supreme Court level, at the Circuit Courts of Appeals, including some things that we've done. We'll get into that a little bit. But I just want you all to know that this episode is for you. If you're a parent, if you're a grandparent, if you know someone who has a child somewhere in schools, this episode is for you. We want this to be a helpful resource as you navigate a maze of laws and regulations in how you can actually advocate for your kids' own interests in the school system to stop crazy things from happening. So, or at least get redress when they do, because let's face it, probably will happen to you the way the world is going. So today I am here with a couple familiar faces and a new one for you. So immediately to my left here is one of our senior counsel, Nick Berry. Nick is first time on the show today. To his left is Alexa Vance, our Director of External Affairs for America First Legal. And to her left is Ian Pryor, who is another senior counsel here at America First Legal. So welcome, everybody. Thank you all for being here, hanging out with me. I guess technically you're paid to be here, so I don't know, it's fine. But I want to talk about some of the things that I just gave in this intro. And I'm just going to pitch an open question to you guys and gal. Is anything I just said shocking to you, or is it disconnected from reality based on the things that we're hearing from parents? And if not, then what do you see as the emerging issues, the emerging legal issues that are affecting parents and that will affect parents all across the country this coming school year?
No, I don't think anything that you said is shocking. I mean, I think what's shocking is that we are still dealing with these issues, right? Despite the momentum that we've seen from the Supreme Court and the federal appellate courts, despite the momentum that we've seen from the Trump administration, the Departments of Education and Justice, schools are still doubling down on this. I mean, look, we had a decision earlier this year where the Supreme Court said clearly, schools cannot facilitate gender transitions of children without parental notification and consent. Yet schools are still doing this. I don't know what it takes for a school district or a state to understand that the Supreme Court is the law of the land when they issue an opinion on these things. So we're getting tools to fight back, but it requires parents to really be active in holding these school boards accountable and holding their school systems accountable in order to see lasting change.
Nick, to Ian's point, and based on the things that you've seen and you've dealt with, Is this kind of situation where parents can just kind of assume that somebody else is going to take care of business for them? Or do parents have a role? Do they have things that they can actually do?
Yeah, parents definitely need to get involved in their kids' education and to keep these school administrators accountable. One of the wokest education pipelines is actually educators. It's librarians and then educators. So your teachers, your school administrators, the education pipeline they're going through is training them that this is what they have to do and this is how they have to educate kids. And it's simply wrong. And so without parents stepping up and advocating for their children, it's going to continue to be a problem across the country. Like you said, red states, blue cities, it doesn't matter. It's a problem everywhere.
I don't want to sound like an infomercial here, so I'm really trying not to. But Alexa, we have a resource on our website for parents across the country. Could you talk a little bit about what is on there and what it has in this particular resource?
Yeah, so we have toolkits actually in our Parent and Student Resource Center. So if you are a parent of a child who is going to school and you think that the school may be taking action that is unlawful related to your child, whether that's regarding curriculum or bathroom policies, you can go to our website. We have all of these resources for parents. And you can actually download template letters and get information on what you as a parent can do to help support your child. And like Nick said, fight back against some of these radical school administrators.
And one of the things that we're going to continue to see and that I think is not reported on are surveys that schools give to children. And you think a survey from a school might be something simple, but it's not. It's getting into their sexuality. It's getting into gender identity stuff. It's getting into whether there's guns at the house, how the parents treat the kids, like all of these really private matters that the PPRA says parents have to have notice of. They have to consent to. And schools might do this in kind of a sneaky way. At the beginning of school, they send you some form that says, we might perform surveys with your student this year, sign here. And parents are signing it, not thinking twice. But they need to think twice because these surveys they're getting aren't normal surveys that kids would get. They're really invasive, and parents have rights to opt out, to deny consent so that their kids don't have to do it. And we have, in our toolkit, letters that will help you do that. And if the school doesn't listen, you can file a complaint. And we have things on there that will help you do that too. So,
yeah, something you said earlier about the pipeline, teachers, administrators, right? And what we see is a theme of teachers that they want to be friends with the kids, right? They want to have every viewpoint into this child's lives. Did it not work in like the 80s and 90s? Because I remember going to school and the teacher was someone where, okay, she's going to give us tests and I better not get in trouble. Because if I get in trouble, she's going to call my parents and then I'm going to get even more trouble. So you had your parents here. You don't want to get in trouble with them. And you also don't want to get in trouble with your teacher. And you want to perform well in school and do well in school. Now, right? Now the kids they don't have to worry about the teachers calling home, right? Because they can't share those things. The policies say if Johnny is Judy in school, you, the teacher, are prohibited from telling the parents. I mean, what else are they prohibited from telling the parents? That Johnny got an F on his algebra test? Because I could tell you, I think some kids would be very stressed out about that and wouldn't want that call being made to their parents. So, I've said this before on this, but like, where do we draw the line here?
Is this a relatively new thing that we're seeing with these policies of, we can't tell the parents about XYZ, under certain circumstances? I mean, this has to be relatively...
Well, I think a lot of this stuff started in the Obama administration in around 2014. There's a Dear Colleague letter from the Department of Education basically saying, we interpret Title IX, sex means gender identity. That gets rescinded on the first Trump administration. We had a couple of bad cases in some circuit courts in 2020 that I think really put this into overdrive, especially during COVID. So these policies that we're seeing are really the aftermath, 2020, 2021. You look at any of these school districts and they have the same policies with the same definitions. And then you look at the date and it's always June 2021, September 2021. It all happened that year.
Wow. Was it coordinated?
Clearly. I mean,
yeah.
We did a deposition in a case and we asked, where did you get the definition for gender expression? Or where did you get the definition for gender queer, non-binary, two-spirit? And they didn't have an answer. They just pointed us to a website, which was like genderspectrum.org. So they're basing their policies off of a website, genderspectrum.org, which I don't even think exists anymore. But it's clearly coordinated at that time. And I would say too, in 2021, you had this case, this infamous case out of the Fourth Circuit, Grimm versus Gloucester County. Once the Supreme Court denied cert on that case, I think that's when the school board said, all right, we're just going to do that.
Speaking of kind of looking at the old days and comparing them to now, I like to think that I'm not that old, but I guess I am. But when I was growing up, if my teacher, much less any stranger, came up to me at school and said, hey, Gene, like what form of contraception should kids be using? I'd be like, what? I have to go tell an adult that you're like what are you trying to do? Like, why are you trying to ask me this question? That's ridiculous. I mean, that you would call that person a pervert in the old days. And even today, people get in these education settings with these surveys and everything else. And when they're asking kids questions like that, at least Congress recognized with the use of federal funds, with the PPRA in particular, when they passed that statute decades ago, that there were certain things that parents needed to be notified about when it came to surveys, and they needed to have the right to opt out and to say, no, you're not going to ask my kid those things. And we're grounded in, look, I mean, a lot of different things, but also just kind of common sense. In a baseline level of morality. I mean, to this day, if you are with your family and your kids and some random dude comes up to you in the playground or comes up to your middle schooler and says, hey, what form of contraception do you use? Like you would slug the person. I mean, and then you would hold him for the cops and be like, what the heck is going on? Like this person is trying to like proposition my minor child. It'd be ridiculous. But then the school is like, oh, hey, they asked the same exact question on a piece of paper and somehow it's okay. And so, things have obviously changed in the mindset of some of the school administrators and some of the teachers and some of the other folks that you're getting at. But it has always been the case that traditionally schools, education was more of a state and local matter, right? That they would be the places where they would make decisions about the local communities. But federal law does have certain requirements that schools have to meet if they're going to be accepting federal funds, which almost all of them do, and certain rights that parents and kids have. So could you all give me just a couple of examples of federal statutes that are on point in the kind of scope of issues that they cover so that parents sitting at home can just issue spot over the school year? If something happens, if something comes up, there's a whole plethora of them, and I know that we have the toolkits for a lot of them on our website, but, open floor.
Well, I just want to start going back before we get to the federal protected right of parental rights, like going further back than that and where they come from, just so everybody understands where we're coming from. Blackstone said that there were three principal duties that parents had to their children. It was to provide for their children, to protect their children, and to educate their children. And he said the education might be the most important one, that parents have a duty, an obligation to provide for their kids. And with those duties come certain rights. And that's what we're talking about here. The rights that you have to protect your children, the rights that you have to educate them and educate them how you want. And so from there, we have kind of the 14th Amendment due process clause, fundamental parental right is kind of where it comes from, the history and tradition in America. But we have taken that, codified it in statutes like the PPRA, the Protection of Pupil Rights Amendment, or parental rights protected in FERPA, right, where they're entitled to their children's education documents, even though schools are now saying, oh, I can't provide you the gender identity plan we created for your child because it's protected by FERPA. Meanwhile, FERPA exists to protect the parent's right to access that information. And so now they have a whole kind of like a second accounting system for the child and what their education stuff is, that, oh, that's not a FERPA right. That's not a FERPA document. You're not entitled to that one. It's, maybe it's like a laundromat that keeps two books. That's what schools are turning into now. And it's kind of weird and scary, but I know there's other things that we can talk about, other federal rights, I guess, or state rights that exist.
And the Department of Education, the Department of Justice has now become very active in enforcing FERPA. which is the statute that provides parents the rights to their students' educational records. And as Nick said, what schools are doing is they're basically separating anything that has to do with gender identity and saying, well, we're going to keep that in a separate place, and we're not going to produce that via FERPA. And so what you're seeing is, increased activity from the federal government, but also litigation, right? Because this goes back to the Mirabelli case from earlier this year. Can't engage in unconsented facilitation of gender transition at school. What I find interesting is what is the school worried about by telling parents what's going on at school, right? It's one thing if there is a serious risk of physical abuse, which is covered by other laws, by the way. But who are they worried about? They're going to lose federal money if they violate FERPA, and the Trump administration has made it clear they're going to enforce FERPA. On the other hand, if they don't tell the parents, they're going to get sued by the parents, right? So the kid's not going to sue them for giving the parents information. And if the kid wanted to sue them, well, he'd have to proceed through the parents who aren't going to do that. So I'm just curious, and I'd love to hear from some of these school boards what they are actually worried about here, because I don't think they're worried about anything other than catering to a specific segment of an interest group that deems these policies to be, protective of transgender rights or whatever they want to, however they want to frame it.
Super rights.
Super rights. Yeah. Super rights. Well, that goes to Title IX, transitioning, no pun intended, to Title IX, where Title IX is another situation where it prohibits sex discrimination. On the basis of sex, you cannot discriminate if you accept as an educational institution federal funds. Well, school districts in these blue states and these woke school districts say, well, Title IX requires us to give Jimmy access to the girls' locker room based on his gender identity. Okay, Title IX doesn't say that. It says sex. Again, there were some bad decisions interpreting Title IX to mean that where sex would mean gender identity, but the Supreme Court pretty clearly resolved this in June when the majority opinion said, and actually all 9 justices joined in the Title IX portion, sex as used in Title IX cannot plausibly mean anything other than biological sex. So if a school district says, we're required by Title IX to let Jimmy use your daughter's locker room, they are lying.
So that leads to a very basic question. And I'll just go rapid fire, maybe each of you. Do you think that their federal law or the Constitution gives boys the right to go into a girl's bathroom? Yes or no?
Absolutely not.
Alexa?
No.
Nick?
No.
Okay, so there you go, right? I mean, people get tripped up, though. These school boards get tripped up. If it's a threat of litigation, I don't know from whom. To your point, Ian, they get tripped up on some of these most basic things. And in fact, the entire proposition has been tossed on its head because the whole point of Title IX was to protect sex-specific spaces, right? A girl's bathroom, a boy's locker room. There is no federal law that says you just have to allow people to go wherever the heck they want, however they're feeling that day, however they identify. No law mandates that. And so then why are the school boards acting this way?
Well, I would say that some school boards are afraid of getting sued by the ACLU or the boy that wants to use the girls' locker room, right? But the game has changed here because when you're looking at a situation where a girl feels uncomfortable sharing a locker room with a boy and she's told to go use a private area to go change. Okay, now after the BPJ case from the Supreme Court, you can say to that boy, look, you can't use that locker room because it's girls only, right? So he can't sue you. I mean, he can try, but you have good Supreme Court precedent saying, look, we can do this. On the flip side, telling a girl that she has inferior rights to the girls' locker room vis-a-vis this boy, well, that's sex discrimination under Title IX.
Yeah. Well, and they always make the argument that it's not sex discrimination because they also allow while they're allowing a boy in a girl's locker room, they also allow the girls in the boys' locker room if they want. So it's not sex discrimination. You're just confused.
And I have the answer to that.
What is the
right? So if you look at this Scrimeti case from last year, Supreme Court Scrimeti case, they basically addressed that. And they went back to the Loving versus Virginia case. And that was a case that prohibited anybody from marrying somebody of the other race. So look, it didn't say that, only black people can't marry white people or white people can't marry black people. It said everybody, regardless of race, cannot have an interracial marriage. Supreme Court basically says, look, it's the Equal Protection Clause, not the Equal Discrimination Clause. If the question turns on a protected category, that implicates, higher scrutiny. So this idea that you can treat boys just as badly as girls as long as you don't categorize it a certain way, that's not going to work in court.
So, okay, I know lawyers don't like hypotheticals. I mean, if you ask 3 lawyers a question, you're going to get like 30 different opinions, possible opinions, just because that's
30?
Just 30. It's a lowball estimate. But that's just how lawyers are. But I mean, the question becomes, right then, as a hypothetical. So let's just say that next week school starts in whatever county in whatever state, or in 3 weeks. And over the summer, somebody has gotten very confused and decided that they think that they're of the opposite sex now. And it's your daughter is in class, and the school doesn't say anything, but then they go to the bathroom, and your daughter says there was a boy who was wearing a dress who came into the bathroom. Does a parent in that situation have rights that they can sue and litigate over to protect their daughter?
Yeah, absolutely. I think the first step they need to do is communicate with the school and try to get an answer from the school, because if you do engage ultimately in litigation, that's going to be the first step to look reasonable. You went to the school and said, hey, is this an aberration or is this part of your policy at the school? And if it's part of the policy, well, now you have state action that's violating your daughter's rights. And so you can have a claim. At least one of the claims I think needs to be pushed now is now that the Mahmoud case has come out, which said that LGBT books and things like that can't be foisted upon your child at school without notice and an opportunity to opt out of that. Well, if you can't have that, then certainly you can't have a boy going into your daughter's restroom. That seems like a much greater violation for a lot of reasons, safety and privacy concerns as well. And so you would have to be provided notice and a chance to opt out of that situation as well. So at minimum, that should protect you. But there's a whole host of other problems, like Ian was just talking about with Title IX and others. So
right. And in Mahmoud, the issue was these LGBT storybooks. And the court said parents have a right to notice and opt their children out of the LGBT storybooks. Okay, so if parents have a right to opt their children out of books pushing, gender fantasy land, then certainly they have a right to opt their kids out of participating in gender fantasy land by being forced to share locker rooms and bathrooms with members of the opposite sex.
One would think, certainly, again, if the parents have the right, exactly as you just said, and we're talking about a book, maybe it's one of these crazy banned books that the left gets so incensed about someone going on a gender journey and they're a two-spirit, whatever now. And the fact that the court recognized that fundamental right there of parents with the just understanding the teaching and the ideology being foisted upon their kids, it's very, very, it is a good decision, a very good decision and the right decision. But it's also would be kind of crazy for them not to take the next step and say, okay, well, you also don't have the right to be notified that you're going to have, oh, by the way, this year your daughter's going to have 3 boys, biological boys, going into the girls' locker room. They're going to be in your girls' PE class also, and they're also going to be using the girls' restrooms. You would think that would be something that parents have the fundamental right to know about in advance and to do something about in advance without having to, learn about it after the kid comes home from school.
Yeah, absolutely. And schools should not be able to put a requirement on parents to have their constitutional rights violated before they get the accommodation.
Right.
Right. That is backwards. And unfortunately, that's what we're seeing. Schools they'll say, well, privacy. Well, if a parent emails the school and says, I just like to be informed, if my child has to share a restroom or a locker room with a member of the opposite sex so I can, make decisions that we can make decisions as a family. And they say, sorry, we can't tell you that because that would be violating someone's privacy. How is that violating anyone's privacy? You're not asking for a specific name. And guess what? If this person is using the locker room and the restroom in public in front of everybody, how is that private?
Well, it's in a private space, Ian.
Oh, yes.
You got to lock in, don't you?
So what are some of the situations we're seeing play out across the country that we have resources in this Parent and Student Action Center to help parents deal with? What are some of the situations?
Well, I think it's as Nick alluded to, parents not being told in advance that their kids might be put in this situation, whether it's sharing a locker room, sharing a bathroom. There's obviously the situation where, a school will refer to a student by their new name and their new gender without telling the parents, and even misleading the parents when they ask. That's a big problem all over the country. And of course, this is what we see with how schools manage this bathroom and locker room issue, which is if you're a girl and you have a problem with the boy, you're the one that has to go find another place to go. If you're a boy that has a problem with the girl in the locker room, you're the one that has to go find somewhere else to go.
Yeah, and if schools had to provide notice to parents, imagine, you have 300 kids at your elementary school and you have to provide notice to all 300 families. Hey, we have a boy that identifies as a girl and is going to be using the girls' restrooms. We're providing you this notice so that you have an opportunity to opt out. Like, how many families there are going to opt their kids out? I would suspect a majority. And once you have that, well, now what are you going to do? This majority of kids can't use the public restrooms at the school anymore because they're opted out and using something else. I mean, it's an unrealistic, unadministratable problem for the schools to handle. And I think that's actually the way that it needs to be handled moving forward. And it has to be handled under Mahmoud and what the law requires.
And that's probably why they're not giving people the opportunity to opt out, because they knew that if they did, they would.
Yeah. So another issue that comes up, and actually, let's see, it's 2026. So obviously we know about the Garland memo that came out, 5 years ago, which is hard to believe that the Department of Justice, the Attorney General of the United States, issued a memo that basically declared war on parents across this country, even though they say, oh, no, I was only targeting violence at school board meetings. Everyone knows exactly what they're trying to do. Give me a break. Parents learned to speak up a lot during that time, and they certainly did so in Loudoun County. And we've talked about that in some of your experiences there as well. But looking forward to the school year ahead, for parents in the school year ahead, what practical steps? Nick, you spoke a moment ago about contacting the school individually, like just asking questions. That seems to me to be a practical, common sense step for a parent to take when they encounter a situation, whether it's about a boy using the girls' bathroom, whether it's about people trying to transition your own kids, whether it's about records, whether it's about any of these other things that are there. What are some other practical steps that parents can take, whether it's going to school board meetings, whether it's contacting schools professionally, of course, as politely as you possibly can be in that type of a situation, which I know I would be very animated myself if it was my own children involved in these situations. But what are some other practical steps that parents can take as they approach this different school year to protect their children?
Well, there's a lot of resources in our Parent and Student Action Center, right, which are template letters. So, for example, FERPA, right? Educational records we talked about. You can get your child's educational records, request those. PPRA, we have a PPRA letter on there that says, look, I want to opt out of any surveys, right? And I want to view the curriculum. Now, sometimes what schools will do is they'll view that PPRA request as a FOIA request or an open records request. And they'll say, it's going to cost you $25,000. No, not under the PPRA. So you need to make sure, and that's why having this template letter is helpful, that they understand you're exercising your rights under the PPRA. And I'd send a third letter or combine them all in one if necessary, saying I am opting out of anything related to gender ideology, whether it's curriculum, whether it's requiring my students to use a bathroom or restroom with some of the opposite sex, whether it's transitioning my child. I want to be notified and I want to opt out. So it's making the paper trail, because look, if you have a school system that is not very smart and very woke, you're going to want that paper trail, because ultimately that might lead to you filing a complaint with the Department of Education or you initiating civil litigation against that school district.
There's so many things that can be done, and there's a lot of people who are willing to step up. And I think that's a major difference between what happened under the tail end of the Obama administration and now, is that you have a lot of legal organizations who are willing to step up, and parents who have said enough is enough, and they're not afraid of these school boards anymore. I think maybe before there was a little bit of a sense of, well, I don't want to be the tall blade of grass that gets cut down first. People understand what's at stake. Your children are at stake. Their lives are at stake. And I don't think any parent out there has to tolerate someone trying to transition their child in the school place. And it is something that parents have to step up and stop. No one has the right to interfere with that relationship between the parent and the child, and to start convincing them, oh yeah, we can call you Judy at school. It's okay. We won't tell mom and dad, oh, we have a closet here with some clothes that you can wear when you're at school. I think parents are willing to actually step into the fight now. And there's organizations like ours. There's other great groups. ADF is another one, who are willing to take these cases on and willing to fight to vindicate these parents' rights against these school districts who, I don't understand where their motivation comes from to tolerate what has been going on for so long.
Well, yeah. Well, remember, California actually passed a statute, I think it's AB 1955, that directly instructed school districts they could not have a policy that required them to inform parents. It was the opposite of what a rational policy would be. We sued over it out in California, and we actually got a favorable opinion out of the Ninth Circuit on it, which is shocking when you think about the panels that you might get out of the Ninth Circuit. It's a little better than it used to be, but still, I think we had 2 Dem appointees on our 3-judge panel, and we still came out on the right side of it, thanks to Mirabelli that Ian was talking about earlier. But also, I want to say, parents should have some hope. The tide is turning on this, but we have to keep fighting. We cannot stop pressing the issue forward, because the other side's not going to stop. They're going to keep pushing this forward. And in my view, I've never understood how a rational person could look at their child be taken advantage of at school and be transitioned by some school administrators and not lose their mind. How could you in any way think that this is an appropriate thing to happen to your child or someone else's child? But I think the spiritual scales are falling off people's eyes. I think they're seeing the truth for what the truth is, that that's an insane proposition and that we don't have to tolerate it, that it's not something that Americans should have to tolerate in their public school systems. There can be all the other failures in the public school systems that everybody can talk about and knows about, but your kid being convinced that they're a different sex at school is an insane proposition that no one should have to deal with. And I think we have to keep fighting until this is completely stamped out. And I think we're winning and we're getting there. And some of our cases reveal it. The other organizations that are helping, Defending Ed as well, right?
Yep, absolutely. Great stuff out of them.
But it doesn't happen until you get parents who step up to take action.
Yeah, look, there's one of the areas where we haven't seen as much play out in the courts yet. And there's all the many great groups, Moms for Liberty, Defending Ed, ADF, all these organizations out there who are trying to step into the gap here and have been doing great work. But one thing I haven't seen as much of yet, I'm just kind of curious what y'all think, is lawsuits against individual teachers who have actually counseled or facilitated individual gender transitions, grounded in tort, right? And being fought out in state courts. I can't think of many. Maybe there's some federal claims there also. But, do you think that a parent who has a child who has transitioned at school, that there is liability, potential personal liability that faces a teacher or a counselor who undertakes that without telling the parents, keeping them in the dark, doing things basically behind, closed doors and keeping parents out of the picture, is that an area in which people could be held financially liable?
I think it's a tough road, but yes, I think there is a pathway in certain circumstances where you could have liability against a teacher. Obviously, they're gonna plead qualified immunity as a state actor. You're gonna have to show probably deliberate indifference. But given Scrimeti, given some of the other cases we've seen, and depending on the harm to your child has to be harmed, which I think you're hard pressed to say that a child who convinces themselves they're in the wrong body hasn't been harmed. I think that's a pretty easy step to get over. But once you get there, I think there are claims that you could make under current tort regime. But this goes back to what states can do, right? States can open up liability for teachers, right? So states can pass new legislation that says if you engage in this activity, you don't enjoy qualified immunity. You're open to liability to the parent suing you. So, because you're going to get the bureaucrats who don't want to comply with, as Ian said, we have pretty clear Supreme Court precedent now. You're going to have administrators that don't want to comply, that are going to push back. And so one of the ways states can fight back against that, localized bureaucrat that doesn't want to comply is say, hey, that's fine, but you're going to bear the brunt of that liability. So enjoy. And I think that will change behavior.
And one thing I want to go back to the federal side of this and pose a hypothetical and answer the hypothetical myself. A parent says, I'm a parent in this school district. Look, I don't think my child is at risk of this. I mean, they're pretty level-headed, but this policy, it applies to me as a parent. Do I need to have my child go down that road before I can sue the school? No, you don't. And the Supreme Court was very clear on that. Parents are the object of these policies. Therefore, they have standing to sue. And the Ninth Circuit backed that up in one of our cases, and the Third Circuit backed that up in one of our cases. So these policies really put the schools at risk for litigation from just about any parent that objects to this policy. So schools would be very wise to take another hard look at what they're doing here and say, you know what, maybe it's better if we just get parental consent for all this weird stuff that we're trying to do. And you're probably not going to get much parental consent, but let's start there.
Ian, I know we usually do bad legal takes.
I got one if you want to do one.
We'll do a bad legal take, but I want to give you the opportunity to do a bad legal take for all of the American people, but especially the American people who live in Maryland, Virginia, North Carolina, and South Carolina. And, what do you think the future of Grimm is? And can you just briefly explain it to folks what the central holding was and where do you think we're going to go from there?
Sure. So Grimm versus Gloucester County, as I said, infamous case that I think really turbocharged this issue with people using opposite sex bathrooms and locker rooms. Grimm said that sex under Title IX also meant gender identity. And to get to that, it said, well, look at the Supreme Court case in Bostick versus Clayton County. That case had to do with, workplace discrimination, treating somebody that was transgender differently in employment than somebody that wasn't. Now, in that Bostick case, it said this doesn't apply to anything other than this specific instance, and we're not talking about locker rooms or bathrooms. But that didn't stop the Grimm court from saying, this totally applies to Title IX. So as a result, we're going to find that there is a Title IX right and then an equal protection right for students, children, to use the bathroom of the sex that they identify with. Well, the Supreme Court disagreed. And the Supreme Court not only said, again, that sex as used in Title IX could only plausibly mean biological sex, but it also said, and Bostick does not apply to Title IX. And to put a bow on that, Justice Gorsuch, who wrote the opinion in Bostick, wrote a concurring opinion saying, again, Bostick does not apply to Title IX or locker rooms or bathrooms. So every school out there that says we have to do this because of Grimm has lost their justification for doing this. Now, what does that mean? Again, when you're now comparing a girl in a girl's locker room, which can be designated only a girl's locker room, and a boy that wants to be there, you better let the girl have the superior right to that locker room, because otherwise you're going to get sued by her for sex discrimination under Title IX. Now, we'll see where this lands, in the Fourth Circuit and how the Fourth Circuit addresses it, right? What we're seeing from, there's a lot of other circuit cases that are dealing with this. There's one in the 10th Circuit, there's one in the 7th Circuit, and we're seeing the court requesting supplemental briefing on the BPJ case. And what the schools are saying is that, well, the BPJ case only applied to sports. Well, that's not accurate. The BPJ holding applied to Title IX and what Title IX and its regulations meant when they said sex, right? Then it was applied to the sports context. The idea that, as we talked about off camera, that you can segregate sports based on sex, but not locker rooms. So Jimmy has to go play with the boys' track team, but he gets to change with the girls. Right? And locker rooms are an integral part of sports, right? You go to the locker room to change for the sports you're playing in. If having boys compete in sports for girls is a disincentive for them to compete in sports, which the Supreme Court said that's not a good thing, well, certainly having to change with a boy in a locker room in order to play those sports is also a disincentive. So look, I think that the opinions that the other side are going to make aren't going to hold the day. Whether this gets resolved, that case gets resolved at the Fourth Circuit again, or whether it has to go up to the Supreme Court from the Fourth Circuit or somewhere else, I think it's going to get resolved in favor of common sense.
Well, so we've had a lot to talk about here on when it comes to parental rights, the upcoming school year. I just want to reiterate, and maybe this will just be a short clip, just to reiterate for all the parents out there. You have rights under law, federal, state law, that you can exercise and that you should exercise to protect your kids at school. You are not alone. You are not overpowered by these school boards with some of these crazy woke policies that they're pursuing. So if you have a situation at your county, at your school, where you are seeing these things happen, I want you to know you can go to aflegal.org and you can go to our Parent and Student Action Center and you can pull up these resources, these guides that everyone here has talked about today, and you can pull them up for yourselves and you do your research and then contact us. We'd love to talk to you. There's nothing we enjoy more than suing woke school districts. I'm telling you right now, we're all itching to be able to bring more lawsuits on behalf of aggrieved parents and students who have had their rights run over by woke bureaucrats. We are not going to tolerate that. So go to our website, check it out. There's a lot more that we could discuss, but that's all that we are going to be able to cover for this particular segment. And now, in fact, it is time for today's Bad Legal Take.
From viral bad arguments to headline mistakes, we're calling them out on Bad Legal Takes.
Ian, I understand you have our Bad Legal Take for today. So what you got?
I do, and this is out of the Northern District of Illinois. It was actually a similar case to what we're talking about, where a female student sued the school district for discrimination for telling her she needs to scram from the bathroom to make way for the boy. Well, a very leftist judge ruled for the school. We'll see how that goes on appeal. But the Bad Legal Take was that this was on a motion to dismiss, where you have to assume the facts in a light most favorable to the plaintiff. She found that the alleged fact that the student was male was conclusory, and she did not find it sufficient for a motion to dismiss. Okay, I know. So you can't call the boy a boy in a federal complaint. That's not sufficient to indicate his sex? I don't know. I'm very confused by this.
What would be sufficient in their eyes? I mean, I can't even imagine.
I mean, I guess according to her, like, just because, he's a boy doesn't mean he's a boy. I guess. I mean, that has to be it.
It's really, it's crazy.
Are they going to revise the form, the case complaint processing form, and you have to check your gender of the 32 different genders that could possibly be about the different sides on the case, both sides of the V, the plaintiff and the defendant, just to be able to proceed now? Is that what Is that what you're saying?
I mean, she refused to accept a basic fact in a pleading. Like saying, the sun rises in the east. Okay, that should be sufficient for a federal complaint, but I guess not for this court or this judge, because how do you prove it? Like, you have to prove it? Prove something so basic and so clear that happens every day? I don't know, maybe.
The sky is blue. Okay, well, insufficient for the sake of your pleading, sir. I mean, that's wild. It was, well, I think we all know which way that's going to go. Hopefully, right? I mean,
You hope.
Hopefully, yeah.
I mean, Lord knows. That's, Ian. I mean, that just invites so many things, thoughts that I have that I just want to say, but are probably inappropriate for public consumption, because that's crazy. I mean, that's just ridiculous. It's about as crazy as, again, someone asking your kid personal, intimate questions. It just change the context with some of this stuff. If someone comes up to your kid at the grocery store and starts asking personal questions, what would you do? The school's asking those questions, what would you do? I mean, it's the same kind of level of insanity that we do not need to tolerate as a society, as parents, as members of civilization that doesn't tolerate pedophilia, I guess, right? I mean, it's just not a thing that we do. So this is crazy. I cannot believe it.
Can I throw in a bad legal take?
Please.
So I'm tired of seeing constantly the other side say that it's about privacy, and it's about privacy of the student. It's about the privacy of the transgender individual. And these people are violating these poor kids' rights. And you have to contextualize that, is that the argument is they're violating the kids' rights by violating their privacy as to their parents. Right? This isn't like they're publishing it on their website for the public to know. The argument is that by telling a parent that, hey, your child is suffering this thing at school, you're violating the child's privacy rights as against their parents. Now, I have some children, and they don't have privacy rights at my house because they're my children, and I'm in charge. And like I said earlier, the duties that I'm obligated to perform for my children give me certain rights. And some of those rights are that I get to know what my children are doing. And I'm tired of seeing constantly on Twitter and everywhere else, normally with a D next to their name, that argues that, oh, it's the transgender kids' privacy rights that are being violated by telling their parents. No, it's not. The parents have the right to know. That's where the right actually comes from. The child doesn't have privacy rights as against their parent when they're 12 years old being transitioned by some administrator at a school. I'm just tired of seeing it. Wanted to throw it out.
It sounds like you've been spending too much time on Reddit and on a SNCC. I'm just saying. We see those things there on Blue Sky, but it's true. You're exactly right. I mean, it is a complaint that people make that is misplaced and is not grounded in reality. It's not grounded in truth. It's a thing that I think we're going to see change over the course of time. We're out of time. Speaking of time, we're out of time for today. Next week is going to be great. I would love to tell you who our guest is, but I can't. But just stay tuned. You're going to love it. It's going to be amazing. No one else gets to have the fun that we do, the interesting conversations that we do. Please make sure that you subscribe to The Arena at America First Legal on your favorite podcast platform. Sign up for our list on YouTube. Follow us on X, everywhere where we are. Just make sure that you spread the word. The more people know about some of these resources, some of these topics, and the more that you can educate yourself, the better prepared you will be. Thanks for joining us. We'll see you next week.